Hey, everybody, welcome to the Bold Inventor Show. I'm your host, Jay Hubener, with my trusty friend, Matt Kolseth. Matt, good day.
What's going on, buddy?
Hey, I'm having a good day. But I want to hit this subject first about searching. Research, let's talk about what needs to happen before you file. I'll talk as briefly as I can on the patent side. I can't emphasize enough. This has always been the number one. It's on the top of the list, right there behind me. Patent research. Look before you lead. One of my soapbox moments is a lot of these, I don't know how many are still out there, but there are some, I'll say, schmucks. Attorneys that will just file everything. Oh, it's a great idea. Let's get you filed. Let me take your 5, 10 grand or more and just smear it and just file it. No way. No way. You deserve, as an inventor, as a business owner, an entrepreneur, potentially, what do you have? How different is what you've invented from what else has already been filed or has been published before? So taking a hard look is so important. And as a patent attorney, early on, I appreciated the fact that research isn't actually something I was trained to do in law school. So I said, you know what, let me go find an expert in research, looking at applications, looking at the latest research, all the publications, all the different classifications, the nuances and the language. And so that's what we've done here at Bold on the patent side is we've got someone who does all that research for us and our clients. And then the attorneys, what we do is look at the results and say, okay, is this, from a legal standpoint, something we can get, put argument forward to an examiner to say, yep, this is different enough. And then the big question for the client is that delta, the difference between what we think is new and what you've got, is that enough that you can make money in the market? Right? Is that invention, right? That scope of rights, all important scope of rights, you can take a look at that. You actually know with a certain degree of confidence how big of rights, how big of an invention you'll be able to get. We always caveat that, of course, with patent research specifically, applications get filed, let's say today, 2024. They won't get published for another year and a half, which puts you out, so I don't know, what's this ballpark at 4th of July in 2025. So it's a huge window where we just can't see, no matter how much research, how good of a researcher you are. So that window is unavailable to the public. So just knowing that there's always a risk that, yes, there could be prior art, there could be things that have been filed in the most recent year and a half, looking at what's known, what's published, that's your best way to move forward.
Oh, that's interesting, Jimmy. So when a patent is filed, it's not publicly available right away.
No, certainly not. I mean, provisionals never get published in essence. Let's say you file a provisional and you never file a non-provisional, it won't get published. It only get published when you file the non-provisional and then around 6 months, 18 months from your priority date. So it's a long period of time.
That's tricky, right? As a patent attorney, right? Because I mean, as a trademark attorney, I'm typically working with like a week where there's a blackout period where I can't see recent trademark applications. But you're looking
you got pace. That's year and a half.
And that keeps you up at night sometimes too, right? But you know, we're looking at a year plus that potentially there's a trade or a patent out there that could conflict with your client's patent application.
Yes, totally.
Now, if someone submits a non-provisional, or I'm sorry, a provisional patent to the patent office, and there's another provisional patent in front of them, is there some sort of interference action that happens?
The examiner won't ever look at it until the non-provisional is filed and they're due the examination. They can cite a 102E. The only time they'll go look, the only time they'll ever go look in a provisional is if there's an ending app that's on the same subject matter. So
like if I file a non-provisional patent and you file a similar, I file a non-provisional, but before I sent the non-provisional and you had filed a provisional patent, I would get notification that there is a potential issue with my application.
Yeah.
Based on your provisional application.
Yes.
Or vice versa.
Yeah.
Okay, cool.
Yeah, it is tricky. It's tricky. It's a long period of wait. So on the trademark side, I mean, let's get into it a little bit on the search. What are some important things to think about?
Yeah, no, it's similar, right? The time frame is pretty long. It's about 14 months currently in 2024 from application to registration if everything goes really smooth. I always tell clients, we should be filing trademarks, early and often because of the process and how long it is. One of the more important conversations, routine conversations I have with clients is around order of operations, because most of our clients are first-time inventors or first-time business folks starting their own businesses. and they need LLCs and they need trademarks and maybe patents. And how do they go about that process? That's,
Yeah.
new territory for a lot of them. And so what we typically recommend is, if you have a name for this product or service, let's clear it first. So we do our search first, our opinion potentially as well. And if everything looks good, then let's go ahead and have you file that LLC that maybe you want to match the trademark brand. A lot of clients like to have their LLC named the same thing as the trademark or the service mark.
Yeah.
Don't need to do it, but a lot of clients like that. So once we have the name cleared, the client will go file the LLC either by themselves or they'll have their business attorney in their state do it. Once that's on file with the Secretary of State, at that point, we will file the trademark using the LLC or the corporation as the legal entity owner. But I always tell clients, like you said, JD, you got to look before you leap because, we're going to file this trademark application if we're not doing research prior to filing it, or, worse yet, you're going to market with an unregistered trademark.
Right.
It could be a year before you're denied by the USPTO if you don't search, or maybe even up to, years after you go to market, you get a cease and desist letter.
What do you tell people? Just, hey, it looks good on my search. They're not going to wait a year or wait until it registers to start their company.
Good question. So, when we do the search and the opinion, assuming everything looks good, or even the knockout search, they have a really unique trademark and they don't need a full search and opinion. At that point, we'll advise them to file the trademark and go to market, right? So if they're not in the marketplace already, just go to market like you're going to get the trademark registration. Cool. So you don't need to wait until the USPTO approves the trademark because that could be 10 months. So once we do the legal research and have the application at the USPTO, just go to market like you normally would.
Cool. Love it. Research. Don't forget.
Yeah, it's research. It's all I do all day is research.